So welcome everyone. My name is Matthew Sumner, and I'll be your moderator for this webinar entitled BVI Innovative Solutions for Chinese Businesses. I'm also here as a representative of the Outbound Investment Group, formerly known as China Offshore, who many of the attendees on this webinar will know from our many summits that we've held for over a decade. And our organization's purpose is to enable the globalization of corporate and personal legacies by providing the best connectivity in the market between overseas providers, like all of those panelists that we have here today, and local Chinese intermediaries as yourselves. Recognized as one of the leading financial centers in the world, the British Virgin Islands has played an increasingly important role in the global economic landscape, facilitating cross-border trade, investment, and finance. The BVI's core principles of agility and evolution have stayed firm and sustainable during global challenges. The jurisdiction has a high level of international cooperation relating to transparency, regulation, and compliance standards, and offers a hugely appealing, stable, and reliable framework for businesses and investors. So today we invite you all to join us on this webinar where you're going to find out about the key developments of BVI's best-in-class innovative regulatory regime and business-friendly environment. As you are informed upon your registration, this webinar is being hosted both in English and Chinese simultaneously. So if you need to change your language settings, you can do so at the bottom of the Zoom app. There's an interpretation button. We will have a Q&A at the conclusion of each panel. A number of you have already submitted questions, so we will answer as many as we can in the time allotted. But if you have any additional queries during the presentation, you can send them in the chat box and we will try to fit them in. So for the first of two panels that we're going to be hosting today, the first panel will discuss two main topics: the latest BVI services and product updates on private wealth and corporate business. And the second is significant innovation and opportunities in doing business in the BVI. On this first panel, I'm happy to announce we have three speakers, and I'd like to introduce them before we get started. Our first speaker, Richard Grasby, who is a partner of Appleby. He's a partner of the Appleby Hong Kong office, leading the private client, trust, and family office practice. He advises trustees, ultra-high net worth individuals, private trust companies, and family offices on the establishment, restructuring, and administration of trusts, including special trusts such as the BVI Vista, Cayman Star Trust, and Employee Benefits Trust. He also regularly assists in estate administration, succession planning, and family governance. Our next speaker, Lorraine Powell, she's a partner of Maples Group, and she's part of the finance team of Maples and Calder in their Hong Kong office. Her practice covers corporate finance, mergers and acquisitions, restructuring and financing, with particular focus on private equity investments, structured finance products, pre-IPO financing, and IPOs of BVI and Cayman Islands companies on global stock exchanges, including Hong Kong, Taiwan, and the United States. Lorraine also regularly advises clients in China on a broad range of corporate and commercial transactions. And our third speaker, Mr. Shane Quinn, he is a senior legal manager of Ogier on the dispute resolution team. His practice focuses on complex and cross-border corporate insolvencies, as well as commercial litigation and trust litigation. Shane has particular experience in applying for and resisting applications for freezing injunctions, the winding up of BVI companies, and anti-suit injunctions. Shane has worked on various cases which have generated important first instance and appellate precedent in the British Virgin Islands in areas such as trust laws, company law, and civil procedure. So welcome everyone, and I would like to dive into the first two topics for this panel. The first being the latest BVI service and product updates on the corporate wealth and corporate business side, as well as the significant innovation and opportunities for doing business in the BVI. So my first question for the panelists today: what are some of the key factors that you believe make BVI an attractive destination for Chinese businesses and investors? And from your own perspective, how do you see BVI has developed its relationship with China over the past several decades?
Thank you, Matthew. Thank you, Outbound Investment. Thank you, BVI Finance, and welcome to the first of many connections with mainland China. I'm just planning my first visit next month. I'm providing a bit of an introduction for the BVI, which actually doesn't need one because of its success over many decades, but just to set the scene for some of the things that we'll hear about later. The key factors that put BVI to the top of the list of potential jurisdictions are things like the developed legal system, which comes from the English common law system with some innovative changes, but also having access to things like the Privy Council as and when needed, which Shane will touch upon later. We have access to service providers such as those on this panel in virtually every time zone, and in Chinese as well as in English, which is unlike some of BVI's competitor jurisdictions. The BVI has very limited taxation, and for the purposes of international structuring, virtually no taxation issues. That the modern systems and infrastructure in terms of filings of documents, access to court processes and things like that. High levels of confidentiality and privacy whilst complying with global standards, which is very important. Flexible company law that we'll hear about later. Some innovative trust products that we will also hear about later. The BVI and China have been very close. I mean, certainly all of my 15 years practicing as a BVI lawyer, China has pretty much dominated most of that work. And just looking at the statistics from 2021, the BVI is the third biggest source of foreign direct investment into the PRC, after Hong Kong, which dominates for obvious reasons, but not outside of Hong Kong, which has a unique place. Then BVI would be ranking number 2 on the 2021 statistics. So that's sort of the basic factors, and the rest of the panel, I'm sure, will elaborate on some of those.
Yeah, thank you, Richard. That's a great intro. And I think probably the most prominent of the points that you made is the access to specialized talent in their time zone, in their language, and has been that way for well over a decade, if not more, at least as far as I can remember. And that's definitely something head and shoulders above most jurisdictions that BVI has done well, is ensure the support of local Chinese businesses in their own time zone, in their own language. And of course, legislation and the product and service offering has stayed up to speed with regulatory changes and requirements from bodies like OECD, which we're going to dive into later. So thank you for that opening, Richard. And I think because of the history of Chinese business people using BVI, of course, many of these structures have seen the full cycle from setup to IPO to family legacy. And of course, it's not always sunshine and rainbows. Sometimes things go wrong, and people do need to know that they're going to be taken care of in case there is a dispute. And so I want to talk a little bit about what remedies people have in case there are any issues with disputes over BVI or related to BVI entities. Is there anyone that can handle that question, just about how things are handled in case there's any disputes related to BVI entities?
Hi, Matthew. Shane here. Yeah, I think I can speak perhaps to the dispute resolution side of things. Richard's already touched upon the fact that the BVI is a common law jurisdiction, and its final court of appeal is the Privy Council in London, which of course can give everyone great comfort that there's a level of consistency in the application of common law principles in the BVI, consistent with other jurisdictions. But what happens before you get that far? There's a commercial court in the BVI itself, and sitting above that, and between that court and the Privy Council, is a court of appeal, which is regional. That's headquartered in St. Lucia, but it's an itinerant court, so it does move around the various different jurisdictions and sits in the BVI a number of times in the year. Of course, if anything's urgent, you can expedite that either by getting a remote hearing, which I'll come to in a second, or indeed by having counsel attend a hearing in St. Lucia. But the commercial court itself, I think, is one of the key things about the BVI that I think is really worth highlighting, because it's a specialized court that sits outside of the High Court. It has 3 dedicated judges at the moment, Justice Wallbank, Justice Mangatal, and Justice Small Davies. And they all have considerable experience. I mean, before Justice Mangatal arrived earlier this year, she was a judge in the Cayman Islands, for example. So there's quite a wealth of experience in the bench in the BVI itself. But the government has dedicated a number of resources to that court. So in order to get into the commercial court, it generally has to be a commercial dispute. And generally the value of the claim would have to be $500,000 or more. But the court can be very, very flexible about that if the circumstances warrant it. The main thing I really wanted to touch on, which I think is important for clients in China, is the court's flexibility around the hearings themselves. So with COVID, the court was very, very quick to adopt the technology of Zoom, for example, allowing witnesses to attend hearings remotely from anywhere in the world, and was sitting outside of its normal court hours to facilitate that. So if you're a Chinese client and you're at a 12-hour different time zone, it's possible for you to have your hearing tailored to suit your needs here in this time zone, in the market that you operate in. And the court's very, very sensitive to that, very, very flexible. And I have to say that that's not something you see very often in other jurisdictions as well. So I don't want to talk about this too long. That really reduced both the costs of the litigation itself, but also costs in terms of travel and just the flexibility around having witnesses give evidence remotely, I think is fantastic.
Yeah, fantastic. Thanks for that, Shane. And I think in particular, the point that you raised, especially we're going to talk about BVI structures involved in IPO listings or as part of an IPO structure. And you can imagine when there's hundreds of shareholders involved, founders, outside financing, et cetera, that's all Far East. The last thing you want to do is have to pack up the team and go to the other side of the world to have a hearing. So it's fantastic to hear that the courts and the arbitration are available to work alongside the time zones of the stakeholders of the various BVI entities that might be involved. And yeah, I think that's quite innovative. The BVI has gone above and beyond to make sure that it stays flexible and stays available to investors when they're needed, in no matter what the matter is, whether it's good or in a dispute or what have you. So thanks for highlighting that. I think it's a very important point. So I want to move on to our next point. How does the BVI's financial industry compare to those in other major financial centers of the world? Obviously, BVI is not the only one, but it's become one of the most popular. And what advantages does BVI offer to Chinese businesses and investors that make it uniquely attractive? Anyone can handle that question?
Hi, Matthew, thanks. Let me talk about this. As we all mentioned, the BVI has been long established as a reputable and stable jurisdictions in which to incorporate. So as a BVI corporate and finance lawyer based in Hong Kong for the last 15 years, I'm going to highlight a few key advantages that the BVI offers from a private M&A transaction perspective. As many of you may be aware, it is very popular in the Asian market to set up a joint venture using a BVI company as the JV entity. So when investors they are looking into potential M&A transaction, the first step would be to carry out a due diligence exercise against the target company. So unlike many of the other offshore jurisdictions, basic corporate information in relation to a BVI company is publicly available, including its certificate of incorporation, memorandum and articles of association, and register of charges, which all can be obtained from a company search. The register of members and register of directors remained as private records, thereby ensuring confidentiality for both the founders and the investors. The M&A being publicly available is one of the features that the investors found very useful, as they are able to verify the independently certain important information of the BVI target company. For example, whether any third-party consent may be required for the proposed acquisition, whether there are any restrictions for allotment or transfer of shares to the investors, whether there are different classes of shares held by different shareholders, and what are the rights and restrictions attached to the shares that the investors are going to acquire. So when the investors decided to make an investment into a BVI company, another key features of a BVI company is that unlike other offshore jurisdictions like the Cayman Islands, most of the corporate matters can be decided by the board of directors, which saves the need and time to go back to all your shareholders to ask for approval. There's no concept of special resolution of shareholders under the BVI Business Companies Act. Matters such as amendments to the M&A, dividend distributions, or redemption of shares, these could be decided by the board of directors alone if they are permitted to do so under the memorandum and articles of association, or by simple majority or unanimous shareholders' consent as the JV partners may wish as a commercial matter. So there's really a very big flexibility in terms of the corporate governance structure. The directors appointed by the investors, they can vote in accordance with the best interest of the investors. This gives the JV partners the confidence that their interests will be fully represented at the day-to-day board management level of the JV entity. And when the BVI company expands its business, making different investments, third-party financing may become necessary. Again, most financial institutions, they are very familiar with the BVI as a jurisdiction and are comfortable providing finance to BVI companies. BVI is a well-established creditor-friendly jurisdiction, offering creditors lending to or taking security from a BVI company many advantages. One of the main advantages is that the security interest granted by a BVI company can be registered publicly in the BVI, and the public registration gives statutory priority to the secure creditor over the subsequent security. So I think in summary, the use of a BVI company as a JV vehicle provides many advantages, from the certainty of common law legal principles to the flexibility that parties can model their corporate governance to suit the business needs. So BVI continues to play a very important role to Chinese business and investors in corporate and finance transactions.
Thank you, Lorraine. Yeah, so I think for all of those who are on the call, of course, the type of law that exists in jurisdiction is important, but if you look at the very specific mechanics of how the BVI, corporate law is set up, these type of provisions allow you certain flexibilities that do not exist in other jurisdictions, and then we add on top of it the dispute resolution, and of course the ever-evolving regulatory framework and the legislative framework that exists in the BVI. So, some of these finer details that Lorraine was just mentioning is very important when you're considering, how to manage the interests of the company, the shareholder interests that may not exist in other jurisdictions. So thank you for highlighting all that. Moving on to the next point. So what are some of the latest services and product updates on private wealth and corporate business in the BVI? And how can Chinese businesses and investors benefit specifically from those? Is there anyone that could field that question?
Yeah, I'll take that, Matt. Thank you. Following on from Lorraine, obviously the main product, if that's the right word, the main structure for private wealth is actually the BVI company itself. It is so popular and efficient that it's a generic name for any offshore company in this particular part of the world. It's called a BVI. That's how successful BVI has been. The company's law is very modern, very easy to manage. Things like paying dividends, not having to have par values of shares. The BVI allows reserve directors. Things like that are all aiding the BVI holding company to be used by multitudes of private wealth structures across the world, probably as the number one option. If individuals hold those shares, then the probate registry has undergone some modernization in recent years and is very used to international client base, because obviously most of the people who own BVI shares are not from the BVI, unlike other jurisdictions. So that's very internationally outlooking. In terms of more formal structures, things like trusts, then if you've got a BVI company, then the obvious choice for your trust in many cases is the BVI itself, because you're keeping the law in the same jurisdiction, you have existing relationships with service providers, etc. And the BVI does have very modern trust law. So just for example, you can have non-charitable purpose trusts in the BVI. You can't, by way of example, in Hong Kong or Singapore, so in this part of the world. You could have a perpetual trust or a very long duration trust in the BVI, which you can't in Singapore, for example, which is the main jurisdiction in this region. You can have the statute gives you very extensive reserved powers, which is radically different from Hong Kong and Singapore. And that in itself drives a lot of business to the BVI. The Vista Trust is with due respect to Samoa and Labuan, is unique in the sense that it actually, by a statutory mechanism, governs the relationship of a trustee as shareholder of a company. That's very innovative and very useful for segregating control and supervision type issues. You can also have a private trust company, and certainly the BVI scores very highly in terms of cost and convenience with a certain level of regulation. Again, we don't particularly want structures with no regulation, but there's a very good balance in the BVI for private trust companies, and the statistics would show that it's the most popular jurisdiction that in this space. And then we'll hear about this later, but certainly from private wealth, some of the fund structures can be utilized by family offices, things like the incubator funds, approved funds, and looking at what's called club deals, which effectively, because there's 2 or more people joining together, is a fund, but I'll leave that to the later panel.
Yeah, thank you, Richard. So, I mean, similar structures that you might hear in other jurisdictions, but I think, you know, the point is that BVI has gone out of its way to make sure that those are applicable and that the legislation is updated and that there's unique levers of control and access, you know, when necessary to make it work for a family business or for the trustee and the beneficiaries, you know, in a way that probably doesn't exist in other jurisdictions. And if it's any vote of confidence, there's several state-owned enterprises from mainland China who have their own BVI trust licenses. So if that's not a vote of confidence, then I don't know what is. So
yeah, I mean, sorry, just to finish, I mean, the BVI had extensive trust law revisions in 2013 and 2021, and also internationally expected things about dealing with mistakes, dealing with variations of trust that other jurisdictions have also been copying or catching up on. So it's a world leading.
Yeah, that's the best form of flattery, right? Is to copy or to imitate. So thank you for that, Richard. And I think you know, there's some issue, especially with the, you know, there's another aspect of this. Chinese is very much now in the transition phase of first generation wealth to second generation wealth. It's their first time going through the real game of inheritance and how to deal with that, especially as not all assets can be transferred, you know, mainland China assets can be transferred into an offshore trust. And so there's obviously issues like probate. How does, you know, BVI deal with probate? Is that something, especially from a Chinese perspective, that's a very interesting and complex topic? Is there anyone that can talk about probate from the Chinese perspective or the BVI's perspective on probate?
Yeah, Matthew. So the probate regime in the BVI is actually quite modern and developed as well. So the probate rules in the BVI have been developed in such a way as to really take out a lot of the bureaucracy that might exist in other jurisdictions as well. So it is relatively straightforward in the sense that there's a dedicated High Court registry division for probate. So there is a direct point of contact for practitioners in that area. One of the things I did want to mention just on this was that when it is complex probate and when there are administrators appointed over an estate and those administrators are professional, obviously the cost of that can be quite high. But there's been a number of related decisions recently by the Commercial Court and the BVI that have that I think Chinese investors can take some comfort from. And so one of those simply says that the level of accountability from a professional estate administrator has to be quite high in terms of what they're charging to that estate. So they really do have to give a line-by-line account really of where the money's going and what time they're spending on doing the job. So that transparency is fantastic, I think, for anyone who's not really in this space normally on a day-to-day basis. And the related decision then is that ordinarily when applications are taken to court, it's the estate itself that pays the costs. And this is the first judgment in the Commercial Court and the BVI that really emphasizes this point as a matter of common law. It's a long-standing English principle. The court won't allow the estate to bear the costs of applications and litigation brought before it if it can be shown that application or the litigation was genuinely hostile So the court won't allow people to go off and just bring any old application seeking directions or trying to disrupt the administrators from doing their job or to gain an advantage over other beneficiaries. If it's genuinely hostile litigation, you're going to pay for it yourself. So I think as a destination for probate, the BVI is quite attractive.
Yeah, that's interesting. And I think there's a lot of technicality to that, as you know, what classifies as hostile or not. And I'm sure you have some case law or some cases that you could reference if there was family offices or beneficiaries of BVI trustees who are clients of the people who are joining us today, that if they want to reach out to you, they could get into the details of that, because I think that's a very important distinction that BVI has compared to other jurisdictions out there. So thanks for that, Shane. Appreciate your input. What's the opportunities that BVI presents for Chinese businesses and investors, and how have you guys seen BVI being used so far up until today? Anyone that can handle this question?
Let me have a go. I think we all agree that BVI definitely is the most popular offshore jurisdiction that the Chinese business they like to incorporate. The popularity of the use of the BVI companies is driven primarily by like all the things that we discussed about earlier, including like the flexible corporate framework, the friendly court system, but also their low administrative costs, which provides cost saving for business owners looking for company to hold assets or operate as an entity for investment. A BVI company can be formed on a same-day basis. This is one of the premium services offered by the BVI registry. The companies are allowed to register company names in Chinese, which is good for branding for Chinese business. It only requires one director who does not need to be a resident in the BVI. There's no capital maintenance requirements. All it needs is just to maintain a cash flow and balance sheet solvency. There are no restrictions on scope of business or prior approval from BVI authority, with the exception of like special restrictive industries like the insurance or banking. The BVI, as Richard mentioned in the beginning, the BVI also benefits from the presence of all of the top tier offshore law firms and service providers who are very experienced in advising Chinese founders and investors for many years. Many of them, they are based in Asia time zone, able to speak Mandarin, able to read and write Chinese documents. And I think last but not least, the BVI government has established a representative office in Hong Kong, BVI House Asia, which shows BVI's commitment to China. For example, when you're BVI companies, you require a certificate of good standing. Once you apply the certificate from the BVI registry, you could choose to pick up the original certificate from BVI House Asia in Hong Kong in the next day or so. So this is really convenient for a lot of our clients.
Yeah, those are some very great distinctions. And I myself witnessed the opening of the BVI House Asia, and I really think in terms of the services and the presence that, well, the BVI government, but also the private sector has there are truly unique. Many offshore jurisdictions, low tax financial centers, have made inroads into China and have become popular to a certain extent. But I can say that I don't think any jurisdiction has the same level of service from the government and the private sector, literally on the same time zone in the same country as BVI does, as to for the Chinese business owners and investors. So that's a very good and important distinction. So that actually brings us. That was my last question for the first panel. So thank you for giving your contributions. Are there any final points that you'd like to make that we didn't cover on those questions before we move on to the second panel? Okay, perfect. The next panel, we're going to be focusing a bit more on digital assets and how BVI is evolving in the sphere of global business, investment, etc. And so I want to introduce our next three panelists. The two main topics we're going to cover are the digital and virtual assets, along with the related rules and regulations that exist in the BVI. And the second point is how BVI is maintaining its leading position and providing sustainable adaptation for global investment. We already talked a lot about that so far from the private wealth business and the corporate business side of things in the BVI, but we're also going to talk about it now in the context of funds and virtual assets. So I'd like to introduce our panelists. First up, Chris Page. He's a counsel of Conyers, and he's part of the corporate department in Conyers, Dillon Pearman in Hong Kong. His practice includes many aspects of corporate and securities law, with a particular focus on formation of investment and private equity funds and other investment vehicles. Chris has extensive experience with fund structuring and restructuring, debt and equity financing, and venture capital related transactions. He also advises on the establishment of entities using and investing in blockchain-based technology. So welcome, Chris. I would like to welcome next Christopher Simpson, who's a partner of O'Neill Webster. He's a partner of the firm's commercial department. His practice focuses primarily on corporate and commercial banking and finance investment funds, where he advises a client base of leading financial institutions, corporations, and other law firms on all aspects of corporate finance, including joint ventures, IPOs, private placements, mergers, arrangements, corporate structuring, bilateral and syndicated loans, bond issues, property financing, project finance, and special purpose vehicles, as well as investment funds, crypto funds, and general aspects of corporate law. So a man that can do it all. He advises on investment business and regulatory matters, including fintech and digital assets. So welcome, Christopher Simpson. Great to have you. And our third speaker, James Broad, who is a partner of Morant Ozan Hong Kong in the corporate and funds practice. He specializes in investment funds with a focus on private equity and hedge funds. He also has experience advising on private mergers and acquisitions. His experience includes guiding clients through the initial setup process, the launch of their fund, and then the ongoing operation and maintenance of the fund. He also advises on the establishment of joint venture structures, as well as the structuring and ongoing operation of partnerships and companies. So welcome all. And the two topics we're going to cover are managing digital and virtual assets, along with the related rules and regulations in BVI, and how BVI is maintaining its leading position and providing sustainable adoption for global investment. So the first question that I want to pose to the panelists is, it's not a secret anymore. Digital assets have taken the world by storm. We want to know what legislation and support does BVI provide to investors and managers who want to use BVI for issuing of virtual assets, such as tokens or cryptocurrencies, setting up of an exchange, and what is the regulatory environment like in BVI for anyone who wants to do that? Anyone that can handle that aspect of this panel?
Yeah, why don't I jump in there, Matthew, and good morning to
Thanks,
everybody.
Chris.
So, yeah, there's no doubt that the world's going through great technological changes at this time, with the development of new technologies such as blockchain causing people to look at how things are being done and wondering if there isn't a better and more efficient way of going forward. So we have a virtual world as well as a real world to consider now. And this is challenging jurisdictions such as the BVI to come up with solutions of their own. So how does it remain an attractive destination for business? How much regulation is the right amount of regulation? Are the traditional regulatory frameworks sufficient? And if new regulation is required, what form should it actually take? Well, the BVI's answer to some of these questions takes the form of the Virtual Assets Service Providers Act, or VASPA as it's known, which came into effect in February of this year and has introduced for the first time a regulatory framework specifically designed to regulate BVI incorporated virtual asset service providers. So virtual assets are broadly defined as digital representations of value that can be digitally traded or transferred and can be used for payment or investment purposes. And a BVI company that provides a virtual asset service as a business on behalf of another person will now actually be regulated for the first time. So broadly, the activities caught include providing virtual asset custody services, operating a virtual assets exchange, and then engaging in more general virtual asset service activities such as hosting wallets or providing financial services relating to an issuer's offer and sale of a virtual asset. So helpfully, VASPA, as it's known, lists a number of excluded activities, and these include things ancillary infrastructure such as cloud data storage, solely creating and selling a software application or hardware and accepting payment for services and virtual assets. So those are outside the scope. So virtual asset service providers operating before the Act came into effect have now until the 31st of July to register, and otherwise they must register before they undertake any regulated activity. And there are certain ongoing obligations under the Act, which I don't have time to go into now, but it's also worth noting that a VASP, or virtual asset service provider, must actually comply with BVI's anti-money laundering and terrorist financing regulations and codes of practice. The BVI Financial Services Commission has actually helpfully and quickly, I might add, issued useful guidance on the application process. James, do you want to say something? So we can't actually hear you.
Hi, James.
Hi, James.
I can't hear you.
Yeah, so I think the point is that the BVI has also very helpfully introduced quite extensive guidance, really, in terms of the application process and what an application should look like and what needs to be filed. So the aim really is to be very clear about how people who fall within the scope of this regime can make such an application. I think that's very helpful for applicants who do fall within the scope of these activities, whether it's as an exchange or providing custody services and so on.
Okay, thanks for that. So having looked at the the new regulation in place, it's probably worth now taking a look at actually the other aspect, which is what about BVI companies that are actually issuing tokens? So at this time, a BVI entity that's solely issuing tokens is not actually caught under VASPA. And issuing tokens is therefore not a regulated activity, although this, of course, may change in due course. So such issuers should be aware that whilst the token issuer needs not register under VASPA, there obviously isn't a general obligation to conduct appropriate due diligence and to ensure that obviously you're not doing any business with anybody designated under the sanctions regime or facilitating financial crimes. So it isn't actually without some oversight, but it's worth mentioning that offerings of tokens and other virtual assets has actually raised billions of dollars, and BVI companies have been extensively used as virtual asset issuers. Obviously, for the reasons I've mentioned above, that it's out of scope from VASPA, the popularity of the BVI shouldn't actually diminish with the introduction of VASPA, and therefore we just look at traditional securities rules as they still apply. So in July 2020, the Financial Services Commission issued its guidance on regulation of virtual assets in the BVI. And this made it clear that virtual assets used as a means of payment for goods and services, which provide the purchaser with the ability to purchase goods and services, in other words, utility tokens, would not be captured by financial services legislation. However, where such a token provides a benefit or right beyond the medium of exchange, it may be caught under the Securities and Investment Business Act, or SEBA, and the issuing company would require to hold the applicable license or be otherwise exempted. So, if structured correctly, an offering of utility tokens should not actually get caught under SEBA, as for SEBA to apply, such token must first fall within the definition of an investment, which basically means things such as shares, issuing shares or interest in partnerships or funds, debentures, warrants, options, futures contracts, and other derivatives. But typically a utility token rather than providing the investor with a return dependent on the performance of the issuer or its business, will give the investor a new virtual asset on a blockchain network, often for use in the application or platform developed by the founders of the project to which the virtual asset relates. So whilst these utility tokens may be directly used within the application, so let's say, for example, on a blockchain-based game, for example, these can also be held simply in the expectation that the game becomes popular, which will in turn drive up the demand for and the value of the tokens as more people want to acquire them so they can actually play the game. And if the value of the token is linked only to the demand for the token itself, rather than any returns based directly on any business operated by the BVI issuing company, then the utility tokens would not be regarded as an investment under SEBA, and consequently, no further regulatory approvals are required. So issuing utility tokens have proven actually to be a very cost-effective and attractive means of accessing capital for startups and early stage enterprises. And a BVI company, for all the reasons that have previously been mentioned, they're inexpensive to set up and maintain. They provide corporate flexibility. There's absence of capital controls and tax neutrality, and therefore extremely suitable for this purpose. And there's no reason to suggest that this would change at this time.
That's right. And the other thing that it's done is in the BVI legislation, really as an overarching observation, is it's made very clear what's in scope and what's out of scope, with those very clear exemptions that Chris was talking about, which makes it easier for people using the vehicles to make a decision as to whether they need to register. And then they have a lot of regulatory certainty going forward as to what they need to do. So I think it's a very well put together regime that's really user friendly.
Yeah, and I think just to finish on that, it's been clearly thought out. The BVI has taken its time to consider some of the legislation that's put in place in some of the other jurisdictions, and has really learned from that. And I think it's put in a very, very good piece of legislation which is appropriately regulates this area.
Thanks, Chris, and thanks, James. I want to clarify. I apologize if you made it clear and I didn't hear it clearly enough. So if the entity is issuing a utility token, it is or it isn't under regulation or say guidance under VASPA. I know it's not considered security and therefore it's not under SEBA, but it is applicable under VASPA law, like the governance of this utility token.
So at this time, the issuance by a BVI company of a token is out of scope of VASPA. So VASPA is primarily dealing with the business related to the token. So provided the actual issuer is only issuing the token, which is typical as for the reasons I mentioned, the actual virtual asset relates to the underlying platform, which is not part of the operations of the company itself or the entity itself, then at this time, the mere issuance of a token is out of scope of VASPA. And provided it's not a security / an investment, it would also be out of scope of SEBA.
Thank you.
Now, it is worth mentioning that obviously it's subject to, overarching, rules relating to AML and to ensure that people are proper due diligence is actually done. But that's as things stand as of today.
Yeah, and the follow-up question I was going to ask on that, because we get a lot of questions related to crypto, I was just going to ask, this doesn't mean that if they're issuing tokens to, for example, US citizens or issuing tokens to British citizens, that issuance would have no implication in terms of the domestic regulatory environment in the USA or the UK. Just to say that from BVI's perspective, this is how they're treated. Or am I misinterpreting that?
No, I think that's actually a very good point to make. And we can only talk about the regulation of our own entities. So there is no regulation of the issuer from a BVI perspective. Now, how those tokens would be treated under the securities laws in respect of the jurisdiction in which they're offered, you'd need to take local advice or specific regulatory advice under US or UK law in the case of the example that you mentioned.
Yes. And I think that's a very important distinction. And this is from what I've seen, a very common theme with BVI. BVI provides a business-friendly, tax-neutral, flexible business environment that doesn't absolve you from responsibilities in whatever jurisdiction you're doing business with the citizens of that country or the businesses of that country. Is that you can rely on BVI to provide that type of flexible framework, that tax-neutral framework. But you need to, of course, adhere to the local regulations. You won't be bound by overly stringent or complicated procedures in the BVI, which is what makes it so attractive because of its flexibility and its neutrality. But of course, then wherever you're operating your business, you need to make sure that you're not running afoul of local regulations and laws. So that's a very important distinction. I think the clarification that you made there, I'm not sure about what other jurisdictions do for crypto, or digital assets, but that is this very important distinction, the difference between security tokens, utility tokens, and how BVI handles those particular issues. So thank you for covering that in such detail. So I think, James, did you have any more comments on that? Did you?
I think that's a really good overview.
Great, thanks. So I want to move now on to BVI funds. BVI funds have certainly been getting more attention in recent years, and I'd like to hear from practitioners who practice in the BVI. What do you think is actually causing this shift? As other jurisdictions have maybe been a fund's favorite in the past, but BVI is getting a lot more interest recently. It's always been a very popular funds jurisdiction, but from my perspective, I've seen an insurge in new funds set up in the BVI. And I'd like to hear from those guys here on the ground who are dealing with investors every day. What are you seeing, and why do you think that's becoming so attractive?
Oh, thank you, Matthew. Yeah, I'll take that one. Good morning, everyone. I'm delighted to be joining this panel from Road Town, Tortola in the BVI to be able to share with you some insights on the investment fund space. Now, indeed, BVI funds in recent years have been receiving more attention in the international marketplace, and I'll discuss some of the reasons for that. However, it's important to note that the BVI has been regulating investment funds since 1996 and has evolved as a true player in the global market as the world's second largest offshore investment funds domicile. Now, the primary legislation which regulates investment funds is the Securities and Investment Business Act, often referred to as SIBA. Now, most of you will be familiar with the traditional BVI funds, the professional fund, private fund, and the public fund. Now, the professional fund is geared towards professional and institutional investors investing not less than US 100,000 or its equivalent. The private fund is geared towards investors investing on a private basis or limited to 50 investors. And the public fund is geared towards retail investors. Now, the public fund has greater safeguards and hence is more regulated than a professional fund or the private fund. So those are your traditional BVI funds. Now, in recent years, the BVI has added two new fund products to its repertoire, the incubator fund and the approved fund. And these funds have proved to be very attractive in the marketplace, including in China. Now, I think one key element is that they are subject to a lighter touch regulatory regime, which means they can be set up and launched quite quickly to take advantage of the markets. So let's look at the incubator fund. Now, the incubator fund is geared towards investors, asset managers who want to start and develop a track record and then move into a larger fund operation. So the incubator fund is limited to a maximum of 20 investors, a minimum initial investment of US 20,000 by each investor, and a cap of 20 million US on the value of investments of the fund. So the AUM of the fund. Now, the incubator fund does not require any functionaries, and essentially the directors manage the incubator fund. So this makes the fund highly cost effective and hence ideal for startup managers. Now, the incubator fund is limited to a 2-year term, but this can be extended for an additional year, after which the fund can either wind down or be converted into a more mature type of fund, such as the professional fund, the private fund, or into an approved fund, which I'll discuss now. So the approved fund is limited to a maximum of 20 investors at any one time and a market cap of US 100 million AUM. There's no minimum initial investment requirement. And unlike the incubator fund, the approved fund requires an administrator, but no other functionaries are required. So this fund is ideal for family offices and friends who want to use a fund structure for their investments. So unlike the incubator fund, there's no restriction on the life of an approved fund. So the approved fund can carry on operations for as long as necessary. I also want to mention the approved manager regime. And so the approved manager can be used to manage both BVI funds and non-BVI funds. The approved manager can manage a closed-ended fund with an AUM of up to US 400 million, or an open-ended fund with an AUM of up to 1 billion. So the approved manager also forms a part of that light touch regulatory regime I mentioned. So from what I have seen, you can receive approval for an incubator fund, an approved fund, or an approved manager in less than 2 weeks from the BVI Financial Services Commission, and in some cases within a week. So one other advantage of the approved manager is that it is not subject to economic substance requirements, which obtains in some other jurisdictions. So if you're based in China, you can set up a BVI fund. And even if you have a non-BVI fund, you can use a BVI approved manager to manage that fund. So, we have seen tremendous uptake in the incubator and approved funds and approved managers from clients based in China. And I think those are some of the key drivers as to why there has been an increase in the use of BVI funds over the last few years.
Yeah, Chris, that's a fantastic overview. And even myself in my own personal observations, talking with intermediaries, talking with fund managers, the fact that on the let's just say the entry level side of things, that BVI is a cost-effective and flexible place for fund managers to really, get their feet wet and to try to demonstrate their investment acumen with a relatively low cost structure. And then also, as other jurisdictions have become very, I wouldn't say unmanageable, but let's just say very difficult to deal with because of economic substance requirements and their local regulatory body, BVI still provides a very flexible and light touch framework for certain fund managers to not have to take on all those extra costs that are associated with economic substance in certain cases. So those are two very important distinctions I know personally firsthand, and I appreciate you highlighting those. Thank you, Chris. Was there any other comments on this particular question?
I think it's worth also touching briefly on the closed-ended fund structure, which the private investment funds, which the BVI implemented in around 2020. So this broadly speaking, closed-ended investment funds were not historically regulated as investment funds in the BVI, but they started to be regulated as such. But so that did necessitate a registration. But I think the point to take away really from that is that, similar to how we talked about the virtual asset regime being very carefully crafted, the closed-ended fund regime has also been quite carefully crafted to ensure that it only captures sort of true investment funds and doesn't inadvertently capture things which are not really regarded as investment funds. So for example, say a club deal where a number of people might club together to purchase a specific asset. That's not what most people would think of as an investment fund, but in some jurisdictions, it can still fall within the scope of the definition. And so I think BVI has been quite careful to keep that as a laser-focused definition on true closed-ended investment funds, and kept sort of club deals, entities that aren't aimed at diversifying portfolio risk, outside the scope of that registration regime, which has meant for club deals and project funds, we've seen a big uptick in the use of BVI for those structures.
Yeah, great point and great distinction. Thanks for that, James. Okay, moving on to the next point. We're running a little bit behind on time. Are there any recent developments, such as any recent company law amendments, court decisions in the BVI, which facilitate smoother and faster cross-border transactions? Anything of note that you think is interesting to mention for the audience today?
So there's one thing I think is worthy of mention, which is some recent changes to the Companies Act, and it relates to the restoration of companies. So it's quite complex and quite technical, but on the one side, you've some amendments to restoring companies that have been dissolved, either as a result of a voluntary liquidation or a compulsory liquidation. And then on the other side, you have a completely new regime now for restoring companies that have been struck off. So they haven't been dissolved as such, in the sense that they didn't go through a voluntary or court liquidation process, but they simply haven't, for example, paid the relevant annual fees, or for whatever reason, they no longer have a registered agent. Now, under the old law, those companies sat in a kind of a strange kind of middle ground for 7 years, where they were struck off administratively, but hadn't yet been dissolved. And one of the most common questions I would often get in practice just is from someone saying, look, I want to sue a company, but it says that it's struck off. What does that mean? Or, I want to bring litigation against someone else, but through my company, but my company has struck off. What do I need to do? I think that's now kind of going to solve itself, because the new law basically says that if a company is in default, it hasn't paid its fees, or whatever the default might be, there will be a 90-day window for the company to make good on that default, and after which then the registrar of companies can publish a notice in the BVI Gazette, and from the publication date the company is then dissolved. So it's a very, very narrow window. I think the real outcome of that for people in this space, investors, is that there's going to be a greater culture, I think, of compliance around the payment of fees and keeping the company in good order. I think that's good for everyone. It just brings the BVI up to speed with just global standards and best practice in this area.
Thanks a lot. Yeah, that's very important, because especially in the past 3 years, with all the disruptions due to the pandemic, I'm sure it's been very difficult for a lot of companies to stay up to speed on their records, make sure they're filing on time. A lot of agents have really struggled during this time who are registering companies. So it's good to know that BVI has a let's just say a pathway to sorting out some of these issues. Thanks for highlighting that. Now, the next thing, in the last question, actually, I want to ask, it's no secret that the international landscape for regulation, transparency, global minimum tax, AML, you name it, the screws are tightening, and BVI so far has kept up very well with the pace of regulatory requirements. What have you seen as practitioners on the ground for how the BVI ensures compliance with regulation and standards? And what role do you think that this plays in terms of international cooperation? Why is this an important distinction that BVI makes for itself? What do you think investors need to know about this?
Yes, Matthew. Yeah, I'll take that. So
Okay,
the BVI is a well-respected international finance center, and has always sought to comply with all relevant international financial standards. Now, the primary regulator of the BVI financial services industry is the BVI Financial Services Commission, often referred to as the BVI FSC. And it regulates all financial services activities conducted in and from within BVI pursuant to BVI laws, with the aim of ensuring compliance with relevant international standards. So their remit includes banking and fiduciary services, investment funds, investment business, insolvency services, insurance business, company management, and company registration. Other regulatory bodies which ensure compliance include the BVI Financial Investigation Agency, the FIA, which is tasked with investigating financial crimes. Additionally, there is the BVI International Tax Authority, the ITA, which ensures compliance with cross-border tax matters, including tax information exchange agreements and related regulations. Now, in fact, the BVI has had a tax information exchange agreement in place with China since 2009. The BVI has also signed on to FATCA and the Common Reporting Standard, CRS. And the BVI has its own proprietary beneficial ownership secure search system, otherwise known as BOSS. And above all, the BVI has a robust anti-money laundering and counterterrorism financing legislation, and also significant regulatory legislation, including the regulatory code, which regulates service providers. The BVI is a member of IOSCO and is subject to OECD, FATF, and CFATF evaluation exercises, along with other assessments. In fact, the jurisdiction is currently undergoing a CFATF, which is the Caribbean Financial Action Task Force evaluation exercise. Also, the BVI government is very engaged in the compliance process and ensures that appropriate legislation is passed in a timely manner. The government also meets with relevant international bodies and stakeholders to ensure compliance remains at the forefront of the financial services industry. So overall, the BVI has a very robust regime for ensuring compliance with international regulations and standards. And we certainly expect that to continue into the future.
Right. Yeah, it's a very extensive overview. Thanks, Chris. And it's very obvious that BVI takes compliance and regulation, international standards very seriously. So thanks for running us through that so that the investors on the conference and the advisors and intermediaries here can take note, so that they can feel confident that when they're setting up structures that they're not going to run afoul of any international regulations. Any other comments on this particular point from our panelists? Okay, very good. Thank you, Chris, and everyone who has contributed to this fantastic panel today. That's actually the end of my questions. There was a question that we took from the audience before that I wanted to get your perspective on. This question, let me see if I can bring it up real quick. This is related to funds. What are the restrictions? What have I done here? What are the restrictions, if any, on where the fund manager can be located? And is there any requirements related to independent fund directors for BVI funds?
Yeah, so the a fund is required to have at least 2 directors, and you want to ensure that the directors are able to exercise their fiduciary duties in an appropriate manner. So it's always a wise decision to get directors who can give their own input on their own, merit. No, so the approved manager in particular, which is set up in BVI, can manage funds from various other jurisdictions. We have seen them used to manage funds in other offshore financial centers and onshore. So it's quite flexible, and investors and the relevant manager would just need to look at where the manager will be used and the fund that it will be used to manage. But it is quite flexible and has been used, globally as far as I have seen.
Great.
So on the flip side, on the flip side to that, a manager regulated elsewhere could also manage a BVI fund without any difficulty.
Right. So it's not that they have to be registered present in the BVI as the fund manager. They can actually be in whatever jurisdiction as long as they're a regulated fund manager to perform their duties for a BVI fund.
I think this is sort of a fit and proper test that would be applied.
Yeah, and there's a sort of list of recognized jurisdictions where functionaries can come from. So a manager that's based in another jurisdiction which is recognized can also be used to manage a BVI fund. So there's flexibility all around.
Great. And so that was the question that I think that was most important, that wasn't answered necessarily in the context of the Q&A. You covered a lot of the other questions that we had already. We're a bit over time, so I won't ask anyone to field any more questions at this point. If we get any other questions from the audience, I trust that you guys will be available to answer questions later on. And of course, I think the next question is, when are you guys going to come to China? Oh, wait. Little does everyone know, half the people on this call are actually based in Hong Kong. So we haven't seen you guys for 3 years, but the borders are open now. So for all the intermediaries who are on this call, know that most of the panelists are a 2-hour flight or just a phone call away on the same time zone. And if you're based in Shenzhen, it's even closer than that. So they, of course, would welcome to have a visit from any of you to come visit them in Hong Kong, or if need arises, I'm sure they would be willing to travel over the border, meet you in whatever city you're in, if you have urgent matters that you need to handle with your clients. They've come out in full force today. Some of the premier law firms and experts on BVI in the world are here with us today. So I hope everyone who would join this conference has learned a lot and has been reinvigorated by the support that BVI continues to offer to the mainland Chinese market. The proposition is very obvious and it continues to show in terms of the numbers of registrations, funds, trusts that BVI has with Chinese beneficiaries, managers, etc. So you're going to hear a lot more from BVI Finance and the law firms and practitioners on this panel in the coming months ahead. I'd like to, as the Managing Director of Outbound Investment Group, I'd like to thank BVI Finance, O'Neill Webster, Conyers, Appleby, and Morant, hope I haven't forgot anyone, Maples, for joining us today. It's been a fantastic experience to hear some really insightful and top level expertise at no charge for the attendees today. And we're talking about some of the most premier lawyers in the space. So that's very kind of you for you to spend the time with us and just talk about some of the most pressing issues that are related to the BVI as a jurisdiction. I had a great time. Hope you all feel the same. And thank you to all the attendees. We had nearly 100 attendees come out today. So obviously the turnout was fantastic and there'll be more to come. So thank you, everyone, and wish you all a wonderful day or a wonderful evening, depending on where you are in the world. And you'll hear from us soon. Thank you, everyone.
Thank you.
I will stay online for a few more minutes in case anyone wants to chat. But this brings our webinar officially to a close.
you